Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about a piece of litigation in the New South Wales Court of Appeal, and it relates to an applicant, or today an appellant, and you'll be able to tell from the name what role they have, in relation to an application to bring a statutory derivative action on behalf of a company. Now, what a statutory derivative action is an application pursuant to certain sections of the Corporations Act, and possibly related to bird law as well, but pursuant to certain sections of the Corporations Act, where a shareholder or a former director or some other former office holders can stand in the shoes of a company and bring a claim on behalf of that company. And that is what today's appellant is seeking to do. They are seeking to stand in the shoes of a relevant company, sue on behalf of that company in order for the company to get some money back for itself. That's what a derivative action is. Now, the nature of this company is that the company is a trustee company, and it's the trustee of a trust, and one of the beneficiaries of that trust is today's appellant, if that makes sense. So we've got the company that's a trustee of a trust, that trust has various beneficiaries, and one of those principal beneficiaries is today's appellant. Now, importantly, one of the terms of the trust deed is that any undistributed income, unless there's a separate resolution of the trustee, any undistributed income in a relevant year of the trust gets distributed and shared amongst these principal beneficiaries. And so principal beneficiaries would stand to take a benefit if there's excess income in this trust. That's part of the background there for you. Now, one of the things that frustrates the appellant, or the fundamental operating issue for the appellant, is that there's this transaction in about 2005. And what the appellant says is that the directors of the trustee co at the time, which incidentally are the appellant's siblings, they caused a valuable land transaction to go ahead and be kind of conducted in the hands of parties related to the respondents, parties related to the defendants at first instance, to the appellant's siblings, right? So what they're saying is, you used to be directors of this trustee company, and indeed they still are, and what you did instead of pursuing this opportunity for the trustee company was you went and pursued the opportunity to buy this valuable land for the benefit of your own companies, when that opportunity to buy that land was actually the trustee companies. And that's what I want to sue you for. I want to sue you for the loss that the trustee company has suffered due to you breaching your duties to the trustee company in causing that valuable opportunity to buy that land to be sent off to one of your own entities. That's the fundamental complaint today. Now, the appellant is called the appellant because they are appealing, because the first instance decision in this case went against the appellant. In order to bring a statutory derivative action, you've got to tick these 5 boxes, boxes including notice, boxes including proving that the company's not going to bring the application themselves, best interests of the company, serious issue to be tried, and importantly, proving that you as an applicant, or today the appellant as an applicant, is coming to the application in good faith. This is where the appellant failed at first instance, and this is where the appellant is trying to pick the case back up here now in the Court of Appeal. Now, there are a number of relevant moving parts here. The basis by which the appellant brings their application is that they are a former director of the company. So they're not a shareholder, so they've got no basis to bring a derivative suit as shareholder. Their former status from 1988 to 1994, so many, many years before this piece of litigation, was as a director. And so they're saying, as a director, I tick that box pursuant to the legislation. I am the sort of person who can bring an application like this. I'm a director, tick. And so as a director, I say I satisfy each of these 5 criteria, and I want to stand in the shoes of the company and go and sue my siblings and some other parties in relation to this valuable opportunity, this valuable land transaction that should have been in the hands of the trustee company, but instead my siblings directed away. That is the basis by which the trustee, I'll draw that, by which the appellant draws the claim. Now, the really fundamental issue with good faith, and the court really tangles with this closely, is the application being brought for the vindication of a right of the companies. And that's the fundamental question the appellant has to tangle with, because the appellant has to show the court that the application is brought indeed for the company's benefit and not for some other reason, not for some ulterior purpose. And this is where all the parties, and indeed the court itself with respect, are relevantly particularly engaged. Because, don't forget, the director role ended in 1994, more than 30 years before the reasons for judgment were handed down. The transaction itself was in 2005. And so we've got this fairly significant period of delay here that sort of seems to lean against the appellant showing they came in good faith. Because if, let's say, the appellant was to prove they came in good faith, then one might assume a person in the appellant's position might bring the application pretty quickly after they found out about the transaction they were thinking about. Now, what ultimately happens, to spoil the ending, is the Court of Appeal dismisses the appeal and finds against the appellant. And that is for a number of reasons. Reason one is this delay, this sort of inability to explain this delay. The evidence there doesn't explain it properly. Then there's the distinction between the role occupied as director and the loss suffered. Where the appellant fails is to kind of knit together the alleged loss and their former role as director. Because one of the challenges that a former director of a trustee company is going to have in a case like this is to say, oh, no, I may be a beneficiary of the trust, and the outcome of my derivative application may be to benefit this company, and the outcome of that may be for me to increase my income as a principal beneficiary of the trust, but I'm really only bringing the application on behalf of this trustee company. So the big challenge that the appellant had, the challenge they failed, was to prove they were bringing the application on behalf of the trustee company itself versus in their own interest as principal beneficiary. Now, the third reason they found that difficult was that they'd actually commenced a number of other pieces of litigation in their capacity as beneficiary. And so this kind of adds to the picture that the parties in the court are already aware that the appellant has made complaints about similar actions to those complained of today in their capacity as beneficiary. And then the final criterion that is among the criteria that taken together the court find as dispositive is the compelling, to use the Court of Appeals word, fact that despite the fact the appellant was a director all those years ago, the director had more or less been absent since the mid-1990s, and so the fact they're only re-engaging now to attempt to enforce this right sort of tells against them in an argument that they're coming in good faith. And so the appellant's ultimately unable to convince the court that they're coming on a good faith basis to vindicate the company's rights, where it remains open to the court to conclude they're actually there agitating their rights as a principal beneficiary of the trust. Hope that discussion assisted you, and I'll look forward to chatting again soon over another coffee, potentially another iced coffee, and in respect of another case note. Cheers.